all my dear friends. I, Mansi Acharya from third year LLB, would like to offer my thanks and our regards chief guest who acknowledged our invitation to direct this webinar series on civil litigation. As we all have gathered here on a very important topic, that is scope of inherent powers of the court under CPC, I am sure that you all will feel enriched with knowledge after completion of this webinar. I feel honored to welcome you all once again to this workshop and hope that you all will have a great time ahead. Now, it is my immense pleasure to call upon our IQAC coordinator, Dr. Manoj Kumar V. Hiremat sir, to throw some light upon this webinar.
Thank you, Manasi. Good morning, Vishwanath sir and my dear students. Dr. J. Mallikarjunaya sir is busy in conducting another webinar to UGC HRDC Center of Bangalore University, so he is not present here. So in his absence, I would like to just give a brief introduction to the event, sir. It's again effort on the part of the KLE Society's Law College to prepare our students to the litigation, especially to the civil litigation, about which the students will be knowing less when they attend the theory classes. But if they get to know from the practicing advocates and judges and senior counsels, they will be very comfortable when they step into the profession tomorrow. So in that direction, this series of civil litigation workshop is organized, sir. So in this series, we have heard different lectures from experts ranging from filing a suit also, maybe with respect to enforcement of the decree and appeals, revision and review. So these kind of various practical topics which are very much relevant for the lawyers to start with. So on these topics, there has been a deliberation. Now we have come to the almost end of the CPC, that is where section 151 provides for inherent powers of the civil code. I guess just like Supreme Court of India has a broad power under Article 142 to pass any order in order to do justice, to do complete justice. Maybe in the same fashion, even the civil courts have got a power under Article 151 to do or to pass an order in order to secure the ends of justice. Because the very institution of court is established to secure the justice. So in that direction, if something is not provided in any provision of the CPC or any enactment, still the court has some power under Article 151 to provide some remedy, it seems. So with this limited understanding about inherent power of the court under section 151, now we are ready to listen to the expert talk by Sir Vishwanath Angadi sir. With this, over to the anchor. Thank you.
Thank you, Manoj sir, for introducing us. Now I would like to call upon our faculty coordinator, Ms. Tilaka ma'am, to introduce our chief guest.
Thank you, Mansi. A very good morning. I, Ms. Tilaka, Assistant Professor, KLE Society's Law College, Bangalore. A warm welcome to all for the webinar series on civil litigation organized by KLE Society's Law College, Bangalore. It is indeed my pleasure to introduce our guest speaker for today's session, Mr. Vishwanath V. Angadi, former Principal City Civil and Sessions Judge. Sir has completed LLB 1977 from University College of Law, Dharwad, and secured third rank to university, and LLM from Postgraduation Department in Law, Karnataka University, Dharwad, and secured third rank to university in 1979. Sir practiced as an advocate in trial and appellate courts from 1979 to 1996 and worked as part-time lecturer in law in various law colleges in Dharwad and Hubballi for more than a decade before joining Karnataka State Judiciary. Sir has appointed directly as District and Session Judge in Karnataka State Judiciary on 15/5/1996, and Sir served as Additional District and Session Judge, Bangalore Rural District from 1996 to from 15/5/1996 to 25th May 1996. And also, sir served in various positions in Karnataka State Judiciary. Sir took steps to dispose of more than 28,000 cases in Lok Adalat organized in Belgaum district during 2009 and 10. And Sir took steps to dispose of more than 4.72 lakhs cases in Lok Adalats held in Bangalore in November 2014. Sir also rendered large number of judgments in civil and criminal matters and also other branches of law during the tenure as district and sessions judge at the above postings. And Sir worked as faculty in KLE Law College, Bangalore and Ramaya Law College, Bangalore during the academic year 2015 and 16. Sir is also the guest faculty of Karnataka Judicial Academy, Bangalore, Karnataka Police Academy, Mysore, Administrative Training Institute, Mysore, Karnataka State Law University, Dharwad, Hubballi, and Karnataka State Bar Council, Bangalore. Sir is an arbitrator on the panel of Arbitration and Conciliation Center, Bengaluru, and also arbitrator on the panel of Delhi Arbitration Center, which is an initiative of High Court of Delhi. So far, SAR have conducted more than 120 arbitration cases, out of which more than 90 cases are referred by Honorable High Court of Karnataka. SAR is of expertise in arbitration law and also in the fields of agency and distribution, intellectual property, real estate, state contract, finance banking, commercial contract, insurance, corporate law, joint ventures, and construction and railway contract, etc. And Sir has also experience in alternative dispute resolution, including mediation and conciliation. And Sir is a mediator of Bangalore Mediation Center and also conciliator of Arbitration and Conciliation Center. Sir, we are very happy to have you here and a warm welcome to you, sir.
Thank you, Tilaka ma'am, for making us more familiar about Sir's achievement. Now it is a high time to begin with today's lecture. I would request our chief guest, Sir Vishwanath B. Angadi sir, to talk upon the session. Over to you, sir.
Good morning to Professor Mallikarjun Hiramat, Professor Tilaka, and members of staff of the third year law of KLE Law College. At the very outset, I wish you all a very happy and prosperous New Year. Let this New Year bring you back to your colleges by physical attendance and let you raise to higher levels in your academic career. So with these brief words, the topic chosen is section 151 of the CPC. And Professor Hiramat spoke of the word justice. He made a mention of the thing that the court must administer justice in a given case. And that is the inherent power of the court in the ends of justice. The word or words used were ends of justice. What is called as justice? What is called as ends of justice? As regards justice or ends of justice, what about the history as per what's called as ancient Indian law? For ancient Indians, what justice meant for them? So the point is importance and significance of justice as per ancient Indian law. I'll touch the word justice and then take forward to the other aspects of our study. I took a printout of the particular, note prepared by one of the students of your college on the subject in question. I will develop on the said matter, and you have discussed there a few case laws. I will also touch them also, and I will touch 10 important case laws of the Apex Court, Supreme Court of India, on section 151 of the CPC. Without quoting and mentioning the concerned case laws, I can just complete my topic in less than 10 minutes. And if I close by 10:10, Principal Mallikarjun and Dr. Mallikarjun Hiramat and other faculty and your students will be upset. we return call you, sir, to speak only for 10 minutes. And we spend 15 minutes only to introduce you and to start the session. So I will be here up to, 1 hour or 1 hour and 15 minutes. So with this, as per ancient Indian law, we have got the example of Akbar and Birbal. One day, Akbar asked Birbal, Emperor Akbar asked Birbal that what you would choose if you were given a choice between number one, justice, and number two, gold coins. The question of emperor was whether you want gold coins or you want justice. For which item you will have your choice. And Akbar was taken aback. See, king asking him whether you want gold or whether you want justice. He was amazed. He was taken aback. And the king did not receive answer very fast from Birbal. Then king asked Birbal, you would prefer a gold coin to justice? The question of the king to Birbal was, you would prefer a gold coin to justice? And Birbal told, yes. Birbal told, my choice is I want gold coins. As you all know, gold now is very, very costly. And because of pandemic that went up, now it has stabilized. So he preferred that my choice is incredibly for gold coin and not justice. Then the king was amazed. Why the particular person, Birbal, did not make a choice for justice in place of gold coins? He was perturbed. But king had no mind to ask Birbal why you give the answer like that. Because Birbal was the advisor to the king, and Birbal was very sharp. He was very, he was a man of intellect. Anything he could answer was with due deliberation, due thinking, seeing pros and cons. Then the said court went on for some days, some months, and there were many people in the courtyard of the king. They also were amazed why Birbal made choice for gold coins in place of justice. They were also amazed. So also king, and the news spread to the entire country. Birbal made choice for gold coins. Somebody told he is very, opportunistic. He wants material things, so he opted for gold coins. For years and years, this question lingered in the minds of all people, emperor, all concerned. And one fine day, it so happened, the king was not able to withstand his asking Birbal why you made a choice for gold coin in place of what is called as justice. Do you know what answer Birbal gave to the question of the king Akbar? After so many years, nobody could have the guts to ask Birbal why he told like that. King asked, tell me the reason why you opted for gold coin in place of justice. Yes, anyone? I think you must have read this story, justice and gold coin, or you have not, or you must have heard. You must have just slightly bypassed the thing being told. And the king told to Birbal, it is shocking and sad. I did not know that you were so debased. In turn, I had not thought that you are so fond of gold, or you wanted only material things, material objects. One asks for one does not have. The Birbal told to the king, one asks what one does not have. Your Majesty, said Birbal quietly. Birbal told, I asked you because I had no gold coin with me. I asked you to give to me gold coin. So his answer was, one asks for what one does not have, Your Majesty, said Birbal quietly. You have seen to it that in our country, justice is available to everybody. Birbal told the king, in our country, you have seen that justice is available to everybody in our country. That was the answer given by Birbal to the question of the emperor. So, as justice is already available to me, and I am always short of money, I said I would choose gold coin. So the answer given by Birbal to the emperor. Birbal told, in our country, justice is freely available. Courts administer justice as per law. If there is no law, as per custom, if there is no custom also, to meet the ends of justice, to see that the parties get relief and that unjust enrichment is not there from the other party. The emperor was so pleased with Birbal's reply that he gave him not one but 1,000 gold coins. King gave to Birbal not one gold coin but 1,000 gold coins. In India, law has evolved from customs and religious practices, prescription to the current constitutional and legal system we have today, thereby traversing through secular legal systems and the common law. So, with these brief words, I will start off quickly our main topic of study, and it is section 151 of the CPC. In the note prepared by one of you in this particular note sent to me by the organizer, I just saw you have quoted section 151, 148, 150, and ways to exercise inherent power. And you have touched 152, 153, 153A, and some case law on the point. So I will tell you which are the other sections of the CPC which also have a link with section 151 of CPC. First one is section 2, surplus 1 of the Act, 2.1, meaning of the word code. Code means the code of civil procedure. Section 3 speaks of subordination of the courts. High court is superior to the lower courts. At the lowest level, we got what's called as court of small causes. On the civil side, then we got civil judge at entry level, taluka level. We got then senior civil judge at sub-division level. Then we got courts of district judge at district level. Now we got district judge courts at even sub-division level also. Then comes High Court. High Court has control over the lower courts under its regime. And High Court is not superior. We got the Apex Court, Supreme Court of India. That is hierarchy of courts. So section 3 of the Act states about the hierarchy of courts. A case to be tried before a civil judge at entry level cannot be filed before the Supreme Court of India. And Supreme Court of India can hear appeal, but not original suits. But in some cases, Supreme Court has got power to hear original suits also. That is not our study here. So 3 of the Act important. 6 is pecuniary jurisdiction. I have got power to try cases up to rupees 5 lakhs. Before me, a case of 5 lakhs and rupees 2 is filed. Can I invoke section 151 CPC and take the case and pass order? Saying that in the end of justice, I will take it up. So, lack of jurisdiction, either pecuniary or territorial, is also a thing which we have to keep in mind. 6 is pecuniary jurisdiction of the courts. Then nine is courts to try only suits of civil in nature. Civil court cannot hear a criminal matter. Civil court cannot hear a revenue matter. Tribal by a revenue court. So nine is courts to try all civil suits unless barred by statute, barred by law. So if the law is there which states civil judge cannot try the case, then he is debarred. But generally, civil suits are triable by what's called as civil courts. 10 is stay of suits. Whether a inferior court can order stay of suit filed between the same parties pending before a superior court. The case in which a case is filed and one more case filed at some other court with the same parties on same cause of action, when the concerned court can order for stay of proceedings in another suit filed between the same parties touching the same matter or not. There also, section 10 is relevant for section 151 CPC. Under 151 CPC, the court cannot say, yes, I order for stay of suit filed for the first time in a given court. So 151 cannot be invoked if there is 10 of the CPC which can come into play. Then is 94 of CPC, 94. 94 is supplemental proceedings before the civil court to prevent ends of justice from being defeated. If the court feels that there is defeating of ends of justice, then court can intervene and pass order to maintain the balance between both the parties. So 94 is supplemental proceedings in order to prevent ends of justice from being defeated. And for that, the court may grant what is called as order of temporary injunction, or it may also order for arrest of the defendant, arrest of the plaintiff, as the case may be, and secure his presence. Number three, it may direct the other party to furnish to the court what is called a security in case the plaintiff files a false suit, vexatious suit, to only cause harassment to the particular defendant. The court may ask under 94 of the CPC, you give to the plaintiff security for the cost which the defendant may incur to contest a wrongly filed false suit. And the court also can appoint a receiver to manage property in dispute, because the court cannot wait until the matter is solved, and till then the property may be damaged, the property may disappear, the property may be mismanaged by a third party. The court may order for appointment of a receiver under 94 of the CPC. That's also in the context of 151 of CPC. It is relevant. I will tell you how it is relevant in due course of time. Then court also can pass interlocutory orders which appear to it as just and convenient. So if court feels that we should pass order which is just and convenient to fit the fact of the case, then as you all know, the civil court has got the power to pass such order. Then nextly is section 151 of the CPC, with which we are concerned. Then 152 of CPC, amendment of judgments, correction of judgments, decrees, orders regarding clerical mistake, arithmetical mistakes, accidental slip or omission. And this one, the court can do it by itself, suo motu, or on application by a party or parties to it. Then 153 of the CPC, general power of the court to amend. Court has committed some mistake. It has power to amend its mistakes and bring back the same to the proper legal format, legal stature, and that is court's power to amend any defect in its proceedings or any error in the given case by passing some order if it is to determine the real question in controversy. So to adjudicate the point in controversy,
It's 10 o'clock.
the court has power under 153 of CPC to amend its proceedings, correct its mistakes, to see that there is serving of the purpose of end of justice being met. So 153, 152 are linked with 151. So also I told the previous sections with these brief points. We'll now take quickly what is the scope of section 151 of the CPC. 151 says in very simple words, a very small section of 44 lines, says in very simple words, saving of inherent powers of court. Even though the CPC provides for various rules to fit various cases, but still a case may appear when a given case may not fit any of the rules under the second part of CPC, then the party or in the court can invoke section 151 of the CPC, that is saving of inherent powers of the court. So civil court by its very constitution has got the power to pass any order. For what purpose? That is, nothing in CPC shall be deemed to limit. CPC cannot limit or curtail or otherwise affect the inherent powers of the court if the court is passing order. For what purpose? If it is required for the case to achieve what's called as ends of justice. So nothing in the CPC shall be deemed to limit or abrogate or otherwise affect the inherent power of a civil court to make such orders, to make such important orders, or as the case may be, required for ends of justice or to prevent abuse of process of justice. See, in CPC, what Order 8 Rule 1 says, the defendant appears, and as per section 8.1 of the CPC, the defendant shall file his written statement within 30 days of service of summons on him. And the court can extend time up to 120 days from date of receipt of summons from the court. Court has no power at all to grant time beyond 120 days from the date of service of suit summons on the defendant. So Order 8 Rule says last limit is 120 days from date of service of the suit summons. Beyond that, court has no power. So whether it means that a defendant who wants to file his WS after expiry of 150 days, there is delay of 30 days in filing his WS. Can you say that the court cannot take on record the WS filed by the defendant after expiry of prescribed 120 days from the date of service of the summons? So here, law is specific, but still the applicant may say to court, sir, I had heart attack, I was in hospital for 3 weeks or 4 weeks, and due to COVID, as you all know, COVID, even High Court, Supreme Court, they are permitting you file now also. Suits will be filed in March last year, could be filed now also up to 31/1/2021. See, there is extension of the period of limitation to file suits which were to be filed in March last year, even now also provided it's filed within 31/1/2021 as per orders of Supreme Court of India, in the PIL filed before it, and also as per circular and order of our High Court. So my point is, when the law can permit you to file the suit now, after a gap of 8 months, and if you had not filed suit in last March, it would have been time barred. There we see that to see that end of justice are met, this particular order is made. That is invariable in section 151 of the CPC. Specific provision is not there. If COVID comes, court can extend. That provision was not there. But court stepped in and court says, yes, because of pandemic, yes, we know you could not move out. Because of pandemic, you lost your job, or you had your less earnings, and you could not pay now the fees to advocate or pay the court fee, as the case may be. So there is extension of time to file suit even now up to end of this month. So the point is, abuse of process of court, if it is there, the court can enter upon, even though CBC does not provide elsewhere, and see that ends of justice are met by it. So to prevent abuse or misuse of power of the court by a party, and to see that there is meeting of ends of justice. And the point is, in spite of the CPC saying a given thing, but still the court has power if it is with the purpose of protecting interest of both sides, to see that the equilibrium is properly maintained, properly balanced, and to prevent abuse or misuse of the process or powers of the court. That is the main thing with which we are concerned. And 151 CPC, I told you, a very small section, and what is its import, or in what cases we can apply the aspect of this particular 151 is to be seen by us when we can invoke section 151 of the CPC, or when the court can invoke by itself 151 of the CPC and grant relief to a party or to the parties. The question is, when the court can invoke section 151 CPC, in what cases? I'll give you some what you call test examples. The first point is whether section 151 of CPC can be invoked by the court or by a party in the appellate stage. Say, suit is dismissed or decreed, the matter goes in appeal to the appellate court, whether the appellate court can invoke section 151 of CPC or not. First scenario. Number two is appointment of a commissioner by a civil judge of a given place. The civil judge appoints advocate as the court commissioner. For what purpose? To go and seize the account books of the plaintiff. The court appoints advocate as the commissioner to go to the office of the particular plaintiff in a suit and seize it and bring it back. And this order, the court passes under section 151 of the CPC. Whether this order is proper or not. That is the second question. I think you are following what I'm saying, or you're not following. My questions, my problems you're following, because nobody is even nodding also. And I'm just seeing all our, in deep thought. And that was started at 9:30. We're all fresh. And for me to take class at 2:30 after lunch will be very Herculean task after lunch. And that too, if we had more of rice and sambar as our main food, and we see students, we see the audience going to sleep, and we got three types of sleeps: simple sleep, mid sleep, and deep sleep. And the problem is, for deep sleep, somebody must awaken the said person, The other day I saw over TV our former CM Kumaraswamy sleeping on dais of a function organized yesterday by a particular political party. Don't complain that I am saying something else. I am saying by the way. My point is give examples to you which are appealable and which we see every day in the walk of life. Those examples, if I tell, you will catch them up. And whenever you just see somebody sleeping at a given place, you will be reminded of this class only for that purpose and with no other purpose. I have no malice, I have no ill will against anybody. See, I am just here to empower you, that's all. So the point is whether in a given case the court can appoint advocate as a commissioner to seize account books of the plaintiff in a given case. So I told the problem. The third point is in a given case, the plaintiff led evidence, different led evidence, the matter went for arguments. There was gap of about 3 or 4 months. During those gap of time of 4 months, the defendant thought that I must produce some compact disc recorder, compact disc containing talk between the parties, which took place after date of closure of evidence of defendant. He moved the court under section 151 of the CPC. Can court permit the defendant to recall PW1 and PW2 of the plaintiff for purpose of further cross-examination or for confronting the audio tape amongst those two persons of talk held on a given day or not? Once the case goes for arguments, whether the court has the power to invoke or party has the power to invoke section 151 CPC and pray the court to permit him to further cross-examine PW1 and PW2 of the plaintiff. So like this, I can multiply, and the point is, I will tell you the case law on the point. And the fourth scenario is if there is specific provision in CPC, whether and in spite of the provision being there, can we or can the court invoke section 151 CPC or not? The court provides a specific relief under specific rule of law, order so and so, rule so and so for a given purpose. Where got that particular specific order is there? Where got specific procedure, procedure under the CPC? In spite of there being a specific order to invoke a given remedy, can still the party or can still the court take aid of section 151 CPC, invoke it and grant relief by saying that in the end of justice, I'm invoking the section. Can court invoke it or not? So I'll give you 4 important test questions, and my question is you have to answer. If you can answer now, that's fine. And if you're not able to answer now, you may answer at appropriate point of time. So my 4 questions, if you got ready-made answer, any one of you here may tell the answer for those 4 test questions, of which I will now make a discussion as per the dictum of the Supreme Court of India. What I have told are based on the ratio of Supreme Court of India in 4 different cases. I would touch in all 10 cases, subject to I will have time. But a list of 10 cases of Supreme Court of India on section 151 CPC only. When to be invoked, when cannot be invoked. If you're invoking, what care the court must take into account. Court cannot just say, in every case apply 151 and grant relief. What care the court can take. And in the last case, the court grants order of injunction. The court says, landlord, you don't dispose tenant from the premises, even though the lease period is over. Landlord is X, the tenant is Y. Lease is for a period of 1 year. 1 year lease time is over. And in this case, the tenant goes to court. Landlord wants to dispossess me by force by bringing gunda elements. Court says to landlord, defendant, don't dispossess this man tenant unless you go to the court for a suit for recovery of possession of the rented property. In spite of the order of court, the landlord dispossesses the tenant, violating order of the court which granted injunction. The question is whether the same court, the civil court, has power to direct the landlord to put back the tenant in possession of the property which he dispossessed under section 151 CPC or not. So all these things are sometimes mind-boggling things. And my point is, don't follow mechanically decision of a given case of the apex court. Apply facts of case before you and read at first what are the material facts before you in a given case. See the facts in that case. If material facts involved in your case are the same thing as material facts in the case of the Supreme Court, that decision has application, but not all decisions. My point is, you have made a list of some decisions I just went through. Those decisions must be stated in the backdrop of material facts involved in that case or in those cases. You are told the case law of, Meera Chavan versus Harsh Biswani. You have just stated what's called as a ratio. Where injunction order of the court is violated, the court can exercise its inherent powers to restore the order. So I told the same thing, but I told you here what I told you the case law. I told you the point. The rent is dispossessed by the landlord, in spite of order of court not to dispossess. Then what court did? Court invoked the 151 CPC, asked the landlord to restore or put back the tenant in possession of the property. So this ratio must be stated in the backdrop of the brief material facts in that case. Without those facts, this ratio, I cannot read it. I can read it if I apply it at random to some case before me as a judge. I pass wrong order. I pass wrong order because I blindly apply the decision of the Supreme Court on a given subject. But here before me, the facts are different. So I just told the example of Meera Chavan versus Harsh Biswani. Then one more case touched by the particular student is Arjun Singh versus Mahendra Kumar. Okay, then so I touched 3 or 4 important principles laid down in the cases of the Supreme Court of India. But my point is, those important principles as per those cases must be analyzed in the backdrop of what is called as material facts in those cases. So my request to the students is, whenever you state ratio of a given case reported in any law reporter, state also small paragraph, the brief facts of the case. Then tell the principle of law involved. Then say section 115 CPC applies or not. So with this, the first case is namely K.K. Veluswamy, K.K. Velusamy versus N. Palanisamy, V-E-L-U-S-A-M-Y, not Swami, Sami, S-A-M-Y, and Palanisamy, P-A-L-A-N-I, S-A-M-I. That is 2011, part 11, Supreme Court cases, page number 275. So this is a case of Supreme Court of India. In this case, the Supreme Court of India laid down the principles which a court must keep in mind, which are 6 in number. while granting or invoking section 151 of the CPC. So the case of Veluswamy versus Palaniswamy is the case of Supreme Court of India on section 151 CPC, or 18 Rule 17 of CPC, or 18 Rule 17 capital E of the CPC, which is amended from 172002. So for these three important sections or orders, this case is an authority. And in this case, the Supreme Court of India told that if there is no specific provision in the CPC to cover a given case, CPC has got separate rules. If the case before you on a point is not covered under any of the orders or rules of the Code of Civil Procedure, so there is no specific provision in CPC enabling the parties to reopen the case for further evidence of the parties. So I told example of a case wherein plaintiff closed side, defendant closed side, the case was fixed for arguments. At that time, the defendant wanted to confront to PW1, the plaintiff, the talks between the parties after the last date of the case, which is stored in a compact disc CD. So in this case, the ratio is, if there is no specific provision in the CPC enabling the parties to reopen the case for leading further evidence of the parties or for further cross-examination of the witnesses for the parties, then section 151 of CPC can be invoked. Abbas Court told, if the CPC does not have a specific provision for a given purpose to be invoked by a party to suit to their requirement for grant of a given relief, then they can invoke section 151 CPC, but not in any other case. If law provides applies on the person of law, then what to apply it under that person of law only. If the CPC does not provide for any other provision, then the party can invoke section 151 of the CPC. That is the principle in the above case. So in this case, Abbas Court told, if CPC provides for a given order, a given rule for grant of a given relief to a party, that rule or order must alone be invoked for grant of temporary injunction. I can't invoke section 151 CPC or invoke only order 39 rules for the CPC. Because law says for injunction, the provision is order 39, rules 1 and 2 for grant of temporary injunction. So the point is 151 cannot be invoked by a party as per his wish and choice. He can invoke only if there are no other specific provisions in CPC to suit to his requirement. So in this case, Order 18, Rule 17A earlier provided that a party may apply to the court to reopen case when the matter goes for arguments, if the party wanted to further read evidence of the parties or for further examination or for a given purpose. So this particular provision, or 18 Rule 17 capital A, which was there to be used by the parties to reopen case for further cross of PW1 or DW1 or to produce documents at a late stage, courts were allowing it. And there was misuse of this particular provision. So Order 18, Rule 17, capital A was deleted by Amendment to CPC in 2002. From 1/7/2002, we don't have Order 18, Rule 17, capital A. By only now, Order 18, Rule 17 of CPC, which states that the court can at any time before passing judgment can call the parties to court, because courts want to put questions to the witness. And when the court calls, then I also have the power to put questions, because when court has called means witness is before the court, then court can permit the parties to also put questions to that witness. So our 18 to 17 now is the power given to court only, but not to a party. And if the party wants to examine, party wants to read evidence of the concerned person afresh, or to further cross-examine PW1, or to lead further evidence by producing the compact risk in this case, the point is there should be IA filed by a party under section 151 CPC only. And if IA is filed under section 151 CPC, then the court shall allow the application. By if it is for purpose of securing ends of justice. So in this case of Veluswamy versus Paliswamy, it so happened that it is a suit for enforcement of agreement of sale of a property. The vendor defaulted to execute sale deed in favor of the buyer. Buyer went to the court for a suit to enforce the contract specifically, and both parties had evidence. When the matter was fixed for arguments, and there was time gap of 4 or 5 months from the date of closure of evidence of defendant and hearing of arguments by both sides, defendant moved the court under IA and section 151 of the CPC, praying court to permit him to reopen the case and to further cross-examine PW1 and PW2 and confront the talk in the CD, the tape recorder, as the case may be. And that was the relief sought for by the defendant as per IA section 151 CPC. The trial court dismissed the application, holding that I have no power. Court told I have no power to allow it. Formerly we had 18 Rule 17A, now that is deleted. We have no power now. And power is court can call. And court told court is not calling. So court dismissed the IA filed by the defendant. At section 151 CPC. The matter went to High Court. High Court confirmed the order of the trial court. High Court told no law is there to permit you to reopen case and produce now the compact hard disk. You ought to produce it long back. And the court did not hear that this disk came to place only some time back after the matter was pushed for arguments. Then the defendant appealed to Supreme Court of India. The defendant is K.K. Veluswamy, he is the appellant, and Paliswamy is the respondent and the plaintiff before the trial court. And the point is, what the apex court did is our question. Whether order passed by the trial court and High Court dismissing IA filed by the defendant under 151 CPC was confirmed by the Supreme Court of India or not. That is the question before us in this case. And what is your answer? Whether the Supreme Court of India concurred with the order of the two trial courts and the trial court and High Court, or gave a different order. Here, the apex court discussed the scope of section 151 CPC. It stated 6 important principles. You take a hard copy of decision of this case of Veluswamy versus Paliswamy, take hard copy, read it, and there the High Court, the Supreme Court of India discussed various case laws of the apex court from 1961 till 2011 on section 151 CPC. This is, in my opinion, an important judgment on the topic in question. So, the first important principle laid down by the apex court is that section 151 CPC is not a substantive provision creating or conferring any power or jurisdiction on the court. 151 is not a substantive provision creating or conferring any power or restriction on court. I have no power to decide a case of a given type. 151 cannot give to me power. So, jurisdiction or extra power, I mean, not concerned. So, it's not a substantive section. What is called a substantive section? Substantive, law. See, we have got, the Substantive Law Evidence Act. They speak of principles. We speak of CPC Part 1, Substantive Law. CRPC also, we got we got also the IPC, substantive and also procedural. So the point is, 151 cannot be, 151 is not a substantive provision creating or conferring any power or jurisdiction on court. It only states that the court has got discretion in a fit case. The court has got its discretion in a fit case, and that is inherent in every court, to see that it renders justice as per law, that is as per law, and to do what is right, and to undo what is wrong, to do what is right, to undo what is wrong, and to do all things which are necessary and required to serve ends of justice and prevent abuse of power of the court. That is the first important principle of the above case. The second principle is namely section 151 of CPC states that if CPC does not provide in its code or in its rules expressly or impliedly or by implication on any procedural aspect or matter. So, we got CPC, there's no specific provision of law to fit a given case. Then the ruling says the court can invoke section 151 CPC and see that justice is administered to the parties. So the CPC does not provide any rule or source for a party to tap the court of the court, to tap the door of the court, and in that case, if the CPC is silent on a given thing on which the party is tapping, then the court can invoke section 151 CPC and use its power to suit to the situation if ends of justice require. So CPC, we don't have specific provision. So in the same case which I told, to reopen case 1817 A was deleted about 18 years ago, and now I want to file the court an application to reopen case. Then court told we can invoke section 151 CPC, allow it, permit party to produce the CD, let him cross-examine, then go forward, because as per defendant, that talk contained what transpired to the parties some time back with regard to that transaction or suit matter in question. That is the second point. The third point is the court has no power to do what is prohibited by law or CPC and section 151 CPC. If law prohibits doing a given thing, court cannot grant the relief under section 151 CPC. Court has no power to do which is prohibited by law by invoking section 151 CPC. So, if law says you cannot invoke, I cannot put into use 151 CPC. I told 3 of the CPC. I spoke about 6 of CPC. My power is to try case only up to 5 lakhs. I take case of 5 lakhs and rupees 2. 5 lakhs 00001 or 0002. I cannot just assume by myself power and take a case and pass order, because court has no power to do a thing which law prohibits. Law says you go to civil court, you go to senior civil court, file the case there. And if it is like that, I cannot take the case before me because I have no power. So third point is court has no power to do which is prohibited by law by invoking section 151 of CPC. So if the CPC contains provisions for a given topic in question and such power is conferred expressly or by implication, that section only must be invoked by the party. He cannot invoke the section 151, that is the third point. The fourth point is, namely, courts' inherent powers are complementary to the powers specifically conferred upon it. Courts' power which are inherent are complementary to the powers specifically conferred upon the courts. And section 151 CPC is not specifically covered, if not covered specifically on a given point, then we can invoke. So the fourth point says, court's power to invoke 151 are complementary to what? Complementary to powers specifically conferred. What is called as complementary? What is called as complementary pass? What is called as complementary food? You travel by air from Bangalore to New Delhi. They say we will provide complimentary breakfast. You travel from Bangalore to Mysore by Shatabdi train. They say we provide complimentary mineral water. We provide complimentary juice. We provide complimentary snacks. So if we travel, they say we'll give complimentary food. If we don't travel means we don't get complimentary food because they go together. So the fourth point is inherent powers of court are complementary to the power specifically conferred. And section 151 of the CPC can be exercised when matter is not specifically covered under the code, under the CPC or elsewhere. So the point is there shall not be conflict or tussle with what is specifically provided for in the code. Code says you invoke that provision. Then what law says? Invoke that provision only. If code does not provide for, then I can invoke. So the point is, inherent powers of court are complementary to the powers specifically conferred on the court. The fifth point is, namely, court should be doubly cautious when invoking section 151 CPC. Court must be very, very sure when invoking section 151 CPC, because I say law has not given me power as per CPC. I invoke the power under 151 CPC. The fifth rule says court should be doubly cautious while invoking section 151 CPC, since there is no legislative guidance to deal with a matter of procedure. And here the court must exercise its discretion and wisdom. If some judge has proper wisdom and has proper and applies the same properly by applying discretion properly, then the order will be good. When there is no guidance as per law or as per act of parliament, for me, I may say yes. For other, he may say no. Or for one problem, we may have four answers. If there is no guidance, if law provides guidance, then I can say yes, X is X only, Y is Y only. If there is no legal, what you call, backdrop or legal rules to govern a given situation, then the court must exercise its wisdom, legal knowledge, acumen, experience, and then grant relief for section 151 CPC. That is the fifth point. court should be very careful while invoking section 1 CPC because there is no legislative guidance to deal with aspect of procedure. The sixth point is namely power of the court should be exercised with care and caution. I cannot use 1 CPC mechanically in every case, which according to me is not covered by CPC. And if my order is taken to the higher court, and if in the higher court they see that I did not know what the law is on the point in CPC, what happens? The high court may write on me strictures saying that this judge does not know basics of civil law. So my point is power to be used under 151 should be used with care and caution and absolutely when required, not routinely, not routinely. And that the point is the court must not doubt the bona fides of the party applying for that use of power. A court feels that that person is invoked by the party with some ulterior motive or to gain time or cause loss to the other side. Court cannot grant relief. Objection 1 of CPC. That is the sixth principle in which the court must exercise care. So with these 6 points, as per the case law of Wilson versus Paliswamy, my point is, in that case, the apex court set aside order passed by the trial court and high court, which had dismissed AFI by different objection 1 CPC by holding that there is no provision in law to permit the defendant to reopen case for production of the compact disc of talks and for further cause of period 1 and 2. So the apex court held after closure of evidence and when the matter was fixed for arguments and much time has passed in the 2 stages, the defendant came across a CD containing talks of a recent date. Last week, last fortnight there was talk. That talk he wanted to produce before the court, the compact disc. And in this case, the apex court held. Let the defendant confront to the witness PW1 the CD containing talk. And the court invoked section 1 CPC because there was no specific provision of law in CPC to permit the defendant to produce the compact disc and to cross-examine further PW1 and PW2. So this is the case law of the apex court, and I think I made myself clear. I told you the brief facts, I told you the principle, I told you the 6 points, 6 principles of section 151 of the CPC, and at paragraph number 11 of the judgment, the apex court held that section 151 of CPC can be invoked by a party for recall of witness after the case goes for the stage of arguments. That is the ratio in the above case. So the apex court invoked section 151 CPC because in the code there is no other provision of procedure to enable the party to move under a particular order. The order 18 to 17 deals with power of court to recall witness, but not power of party. Power of party was there. Order 18 to 17A. So 17A is deleted from 1/7/2002. So with this, I completed the first important case law on the main topic. If you got doubts on this case law and those 6 principles and the brief factual matrix, you may kindly ask. Any doubts, any queries? Am I very fast or am I very slow, or whether you're able to follow me? Because I am just giving one-way lecture, one-way traffic. And as we all know, highways, one-way traffic. For going one side, coming, we got the other lane and we got divider. And in highways now, there are more accidents because now I got new vehicles, automatic gears, and I got also that speed control. We put 100 only, vehicle goes in 100 km speed only, and thereby the motorist, the car driver, will fall asleep sometimes. My point is, if you have followed, that's fine. If you haven't followed, so tell me. I am there to once again explain to you those principles. Yes? No doubts? If you have doubts, may just put it up. We'll discuss at the end. The second case is 2010, Part 8, SCC, page number 1. The case name is Vinod Seth versus Devinder Bajaj and another. Vinod Seth versus Devinder Bajaj and another. 2010, Part 8, SCC, page 1. Here, section 15 CPC, paragraph 26, 28 up to 34, that are very, very important. And here, I will just tell only the brief points of the given case because I've spent more time on the first case, and now it is 10:45. And here, the relevant important ratio in the above case is that powers of the court on section 151 of the CPC. Here, it so happened that the trial court directed the defendant, the trial court directed the plaintiff to give to defendant what is called as security for rupees 25 lakhs because the suit of plaintiff is false and frivolous. The court directed the plaintiff to give to defendant rupees 25 lakhs as security in case suit of plaintiff is dismissed. At the end of the day, the defendant being harassed in contesting a false suit, the court directed the plaintiff to give to the defendant what is called as security or deposit rupees 25 lakhs as cost 25 lakhs in the event of the suit being dismissed on merits after a full-fledged trial. This order was taken to the Supreme Court of India. And here in this case, whether section 15 CPC can be removed or not. The court removed section 15 CPC, directed the plaintiff saying that your suit is a false suit, there is a mischievous suit. At the end of the day, the case may fall, the case may be dismissed. The court directed the plaintiff to give to defendant security for 25 lakhs in case the suit is dismissed. If case fails, then plaintiff shall give to the defendant rupees 25 lakhs if defendant moves the court for recovery. And for that, the court told no only you give to the court security for cost or damages for rupees 25 lakhs. This question was tested before the Supreme Court of India. In the above case, the apex court, took into account Order 25 of the CPC, wherein it asked the plaintiff to give to the defendant security for cost of rupees 25 lakhs, and the court ordered that it takes time for us to hear a case. It's a case of Allahabad High Court matter. In UP is the state in the country where it has got highest number of pending cases, civil and criminal. Highest number is one state of UP. Ours is not much. Ours is under around 19 lakhs or 20 lakhs is pendency of our High Court and lower courts in our state. Total pendency is 4 crores of all India level. That is as on February 1st. That is 3.76 crores cases, civil, criminal at all courts, all India level. And here the point involved in this case is that if the suit of plaintiff is discovered by the court as false and frivolous, what court can do? If the suit of plaintiff is found to be, at the end of the day, as a false suit or a frivolous suit, what court can do? In this case, court asked the plaintiff to give to defendant security for rupees 25 lakhs in case ever suit is dismissed. That is Order 25 of the CPC. The question is, what other power court has got? If the plaintiff is vexatious, false, or filed with the purpose of harassing the defendant. Yes. What about other powers of court? Court has the power to dismiss suit of the plaintiff with cost even of rupees 25 lakhs to be paid by plaintiff to defendant, because defendant was dragged to court, contest a suit which is bad in law. So power of court to levy cost, to levy what's called as lost cost for compensation under section 35 and 35 capital A of the CPC is there. When the provision is there, how the court can now only make up its mind that the suit may fall, the suit may be dismissed. So the court cannot prejudge unless the case goes further and there is recording of evidence. Court cannot prejudge now only and say that plaintiff's suit may be dismissed in future point of time. So in this case, the apex court held that order passed by the court asking the plaintiff to provide security for 25 lakhs as damages to the defendant in case the suit is dismissed was set aside by the Supreme Court of India. The High Court, the trial court invoked section 15 CPC, asked the plaintiff to provide cost for 25 lakhs by way of damages in case the suit is dismissed. So here the apex court observed that if the court provides for specific provision to fit a particular purpose, that provision must alone be invoked. Court cannot invoke, party cannot invoke section 150 CPC. So by got order 25 is there, by got section 35 of the CPC, the court could invoke those sections, but not section 15 of the CPC. So the apex court observed that if there is a specific rule under the CPC under which the party or court can take shelter, then we cannot invoke the power of the court under section 151 of the CPC. And in this case, the apex court set aside order of the High Court directing the plaintiff to file affidavit saying that he will pay to the respondents, defendants, rupees 25 lakhs as cost in case the suit is dismissed on merits of the case. So with that, the third important case law on the point is 2012 part 5 SCC page number 488 Super Cassettes India Limited versus Music Broadcast Private Limited. The provisions are Copyright Act, power of Copyright Board to issue license to the applicant for grant of copyright for a given, article, given work, as the case may be. In this case, section 31 of the Copyright Act is with the power of Copyright Board to grant license to the applicant applying for copyright in a work. It may be artistic work, or it may be a work of a given type. So 31 is power of the Copyright Board to issue license in favor of the applicant, saying that yes, you have copyright with regard to a given thing for a given period of time, subject to renewal as per rules. So here, this Copyright Board did not grant immediately the license for the copyright applied for by the plaintiff. The plaintiff approached the court. The trial court did not grant. In the matter, the High Court of Delhi granted what is called as interim license granting copyright. See, power was given to the copyright board to grant license or refuse it. That was still pending. And the plaintiff told that you protect now my interest. Delhi High Court passed order. You are granted interim license of grant of copyright under Copyright Act. The matter went to Supreme Court of India. Supreme Court told that Copyright Board had one power to reject or grant. It has no power even to grant what's called as interim license of grant of copyright until we issue a regular license granting copyright. So the apex court held in the above case that order passed by the High Court of Delhi is bad in law. There is no provision in law at all to issue license being interim for a given time until the Copyright Board decides to give or not to give or grant license. So when the law itself does not provide the power to grant interim relief under section 151 CPC, because 31 of the Copyright Act says grant it or refuse it. There is no question of grant of license being interim or as an interim measure. So the apex court held power is not vested in a copyright board to grant license being interim, which was granted by the Delhi High Court. So the apex court held that set order of Delhi High Court is bad in law because it conflicts section 31 of the Copyright Act in this case. So that is order 39 of the CPC, 94 of the CPC, 151 of the CPC. So the apex High Court of Delhi invoked 151, 94 of CPC and granted what is called as interim license. Interim license of copyright applied for by the applicant. So the apex court held that it is a wrong order. Section 151 of CPC was wrongly invoked against section 31 of the Copyright Act, which states that the Copyright Board can grant or refuse, and there is no power to the Copyright Board to grant interim license. Say you are purchasing a new car, you take it to the RTO for registration, and whether the RTO can grant to interim RC book, they grant interim RC book. So he has to give it or he has to refuse it. So I purchased a new vehicle, and my wife was perturbed. I told you to buy a car of white color. You purchased a car of black color. Wife is disturbed, and the husband wanted to surprise his wife by buying a car without her knowledge. He brought car in the evening, and the color was black. Wife was shocked. There was tussle. Then what this man did? The buyer, husband, he went to the garage, got the vehicle fully repainted, white color. Then the vehicle was taken to the RTO for registration. RTO refused to register the vehicle. Is it proper or not? In this case, if the said vehicle owner approaches the civil court, can civil court grant injunction or can grant interim RC book in favor of the applicant, saying that until RTO issues license, RTO issues RC book for the vehicle, you use the vehicle. But law says until I register the vehicle, I cannot use it. Law says I buy the vehicle, I have to get it registered with the RTO. Here what I do, I change the color of the car. Now it is a white color car. The sale letter says color of car as black color. RTO says I can't register the vehicle. He goes to court. Court grants order, interim, what you call RC book. Under section 156 CPC, is it proper or not? I've given you a live case which are happening in the courts, in the office of RTO. Yes. The sale letter states vehicle chassis number, vehicle engine number, so and so color. If I change color of the vehicle and take it for registration,
It's 11 o'clock.
the RTO can refuse to register. In that case, civil court has no power to grant injunction. Law says registration of vehicle as per the sale letter, color is white means color is white, color is black means black only. After registration, I can change color, but not on the date I take vehicle to the RTO for physical inspection. So in this case, 156 CPC cannot be moved because law says I cannot do it. Court cannot grant a relief which law says I cannot do it. That is the principle of the Super Cassettes India Limited versus Music Broadcast Limited, 2012, Part 5, SCC, page number 488. The fact of case which I told you is copyright is that is 2012, Part 5, SCC 488, Super Cassettes India Limited versus Music Broadcast Private Limited. The fourth case is namely Meera Chavan versus Harish Bishoni and another. So in your note, the student has prepared this case is there. Meera Chavan versus Harish Bishoni and another. 2007 part 12 SCC page number 201. In this case, the court granted order of injunction, restraining defendant not to dispossess the plaintiff till the next date of the case. Court granted to the plaintiff the relief of injunction, directing the defendant not to dispossess the plaintiff from the suit property. That order was there. In spite of order of court, the defendant threw the plaintiff out of the property and took possession, violating provisions of grant of injunction. Then thereafter, the plaintiff approached the court. Sir, you direct the defendant to give me back to me portion of the property for which the court granted injunction order against the defendant. And the defendant told in the court, sir, there is no provision in law for grant of the relief. He says, you have got the power to grant injunction, order is certain of the CPC. There is no power of the court to direct the defendant to put back the plaintiff in possession of the property which was disposed by the defendant. Whether the court has to allow the application and direct the defendant to put back the plaintiff in possession of property or not. In this case, the appeals court held that if the defendant violates order of court and takes possession of property from the plaintiff high-handedly, then court has power under section 151 CPC to direct the defendant to put back the plaintiff in custody of the property so dispossessed. This is the principle of Meera Chavan versus Harish Bishoni. So the note prepared by you, which I am seeing, just says case name, principle. Facts are the defendant dispossesses plaintiff in spite of order of court, saying that don't dispossess or interfere with this position. So when injunction is granted and is violated, court has power to restore the order on section 151 of the CPC. So with this, the fifth case is namely 2004 part 6 SCC page number 378 Warid Jacob versus Sosamma G. Varghese and others. Here, the apex court observed that even in a given case, the case does not fall under Order 39 of the CPC. Still, the court can invoke section 1 CPC and grant the relief. So the ratio is, even in a given case, the case does not fall under Order 39 Rules 1 of CPC, but still courts have got inherent power and grant injunction if it is to meet the ends of justice. That is the principle in this above case. So, if the law provides for express provision, grant it. If the principle of order 13 cannot be invoked in that case, but still the court can invoke section 1 CPC, and in the end of justice, it can grant interim injunction to the plaintiff in a given case, because it is duty of court to see that it render justice to the parties. Then the sixth case is namely 2004 Part 11 SCC 168 Shipping Corporation of India versus Machado Brothers and others 2004 Part 11 SCC page number 168. So here the question is namely, if the suit of the plaintiff has become infructuous because of an event which took place after the date of filing of suit, X files suit on given date. After 6 months, the suit becomes infructuous because the cause of action may disappear or the property may disappear, and the case may be. In that case, court can invoke or a party can invoke section 1 CPC for dismissal of a suit which has become infructuous. So the matter of property not existing or cause of action for the suit coming to an end. In that case, if the defendant moves the court, asks the court dismiss suit as becoming infructuous, then the defendant can move the court to section 1 CPC, and court in fit cases shall allow the application, because there is no point in keeping on or file a case which is not fit for trial, because the cause of action has ceased to exist as on date. That is the sixth case law of the apex court. The seventh is namely A.A. Ahmed, A.A. Ahmed Ibrahim versus Food Corporation of India, FCI, 1999, Part 7, SCC, page number 39. This is the case of the apex court. And here, if the suit is filed by the plaintiff for recovery of 1 lakh, I filed suit sometime back for recovery of 1 lakh. Now, after a gap of 6 years, I want to move the court to amend the plaint to seek further amount of 2 more lakhs. I want to claim now further amount of 2 lakhs by way of application to amend my plaint under section 1 CPC. To amend the plaint, we got a provision. Order 6 is there. Order 6 rule is rule number 17. That is for amendment of plaint, amendment of WS, as the case may be. Whether a court can invoke section 1 CPC and permit the plaintiff to seek a higher amount of claim, covering also a time barred claim of which I is filed now after a few years from the date of filing of suit. In this case, the apex court held that a time barred claim, I cannot file suit. A time barred claim, court can permit the party to amend the plaint. So the apex court held in this case that since the enhanced claim is now, as on date, is barred by time, court cannot invoke section 1.5 CPC and allow the amendment of the pleadings. So this is the case law of the apex court. So take only 5 more minutes. It is eighth case law is 1970 part 1 SCC page number 732. That is the 9 Singh versus Kuhn Varji and others. Here, the apex court held that the appellate court has no power to invoke section 151 CPC. The trial court or civil court or the original court can invoke section 151 CPC, but not the appellate court. That is the ratio of this 1970 part 1 SCC page number 732. The ninth one is namely AIR 1966 Supreme Court page number 1899. This is Ram Chand and Sons Sugar Mills Private Limited versus Kanai Lal Bhargava and others. So this is also the note. The note given state this case. Ram Chand and Sons Sugar Mills Private Limited, Bara Banki UP versus Kanai Lal Bhargava and others. So in this case, the point is the court, in case of default on the part of director, to come to court as per its order, the court can make suitable consequential order on section 1.5 of CPC. In this case, the court directed a director of the company Ram Chand and Sons Sugar Mills Limited. They called the director to come to court under order 29 rule 3 of the CPC, and the director did not come to court. The court invoked section 1.5 of CPC and held that we can pass the order under that section to meet the ends of justice or to prevent abuse of process of the court. The referent directed by the court did not come. So that particular director abused the order of court. So the apex court held that section 1.5 CPC can be invoked by the party or by the court to see that its order are implemented and that the party does not misuse the power of the court. Lastly and finally, Padma Sen and another versus the state of UP. This is a very important case of the Supreme Court of India. This is the case of 1961, AIR 1961, Supreme Court, page number 218. For appointment of commissioners, the provisions are section 75 of CPC. And also order number is 26 of the CPC. I think you all learned CPC or still you are learning? Still you are studying CPC or you are studying?
We're learning now, sir.
So order section is 75. Read with order is 26 of the CPC. Dealing with issuance of commission by the court, when court can issue commission. So in this case, what happened? The municipal court, that is municipal means the lowest court, civil judge court, in a given case, appointed advocate as a court commissioner to go to the place of business of the plaintiff, seize account books, come back and go to court. So there is appointment of the court commissioner by the court under section 1.5 of the CPC, directing him go to place of plaintiff business center, seize all records, take to court, and give to court custody. Failing which, the plaintiff may make alterations in the account books. This order of court was tested before Supreme Court of India. The plaintiff told, sir, I am businessman, sir. I want account books. How can they seize my account books and take it to court? The case may take 10 years for disposal. The Supreme Court of India, the Apex Court held that the order passed by the Munsif, the civil judge, is wrong in law, because there cannot be appointment of a commissioner to seize and bring account books. What law says? You can ask the plaintiff to provide a copy of the account books, the matter ends. Or what the law says, you can ask the plaintiff to bring to the court the account books, let the defendant examine, or the court can mark it as a document, and the defendant can take certified copy of the entire account books. But there cannot be order to appoint a commissioner to seize account books of the plaintiff and dump them to the court. So the Apex Court held that that order of the court is against the principles of law. Law does not say you can seize the records, bring it to court. What law says? You can take copy of the account books, account extracts. So in this case, the Apex Court held that power of court to show commission must be read with section 75 and order 26 of CPC, and court cannot invoke section 1 of the CPC. Inherent powers of court are in addition to powers specifically conferred on courts, and they are complementary to each other, and that they must not conflict with the main sections of the CPC. 75 in this case, 75 and 26 of the CPC. So this is the case law of the Apex Court on the aspect. Order of the Munsif, the civil judge, was satisfied by the Supreme Court of India. So with this, I have touched the 10 case laws of the Apex Court on the above point. And still I have got some more case laws, but it is fine. I think I made myself clear on the scope of 151, when to be applied, when not to be applied, and when to be applied, what care you must take, what care the court must keep in mind. And if you got doubts on the aspect of this chapter, you may kindly ask, and I'm there to answer your queries or your questions. And I've told you only the things which are in the practical field. I haven't touched the what you call pure theory. I've touched case law. I have also given you important examples which we see every day in walk of life. The example of vehicle owner changing color of car. So yeah, RTO can refuse to register. That is the law of the point. And for that, court cannot grant injunction on section 1 of the CPC. So with this, any doubts are there, I'm there to answer you those doubts and clarify yourself.
I think you should take you have holistically covered all the topics surrounding. There are few questions. If
Yes.
time permits, I'll raise it. I'll ask the questions. So the first question is very general. They're asking, section 151, isn't section 151 very subjective power in the hands of courts, so that courts might misuse the power in some instances? Shouldn't there be more restrictions? Is the first question.
Okay. So the first question of the student Vivek is very, very interesting. He says whether the court in a fit case, as per its discretion, can invoke the section and grant relief. Ex-judge, for the same facts of a case, he says, I grant relief, I invoke. Why judge says, no need to invoke 151, I don't invoke it. And third judge says, via media, half this, half that. If these facts exist, so and so. If not, so and so. And you all know a case wherein our great actor, who was a great actor? Amitabh Bachchan. He runs what's called as Kaun Banega Crorepati. And he runs it not for fun, he makes money. For one show, so and so amount. For one question, he gives 4 options. Option A, option 2, option 3, option 4. So now we got 3 options. One judge says, grant it. Second judge says, don't grant it. Third judge says, yes or no. Fourth judge says, in vacuum. So we got 4 answers for one question. And this 4 answers for your one question is because of the short point. I told you before that. There is no legislative procedure or principles on which you can invoke section 150 CPC. I told you before that. There is no legislative guidance for the court, in which case you can invoke, in which case you cannot invoke. And the ruling says, court in its wisdom, in its knowledge, can grant it or can refuse it. So here, what Supreme Court says, the court must be doubly serious while applying and granting relief to the party, invoking section 151 CPC. So my point is, subject to power, that's correct, but subject to means it must test the floor of law. See, the AC, Deputy Commissioner, has the power to grant license for owning or having a gun or arm license. X man goes, he says, grant it. Why it applies the refusal? Order of refusal will be taken to the civil court, will be taken to the High Court by a writ. High Court then examines, quasi-judicial body should also apply principles of natural justice. He cannot pick and choose. Yes comes, MLA comes, grant it. A poor man comes, he says, don't grant it. So my point is, subjective element is also subject to the case law of the Supreme Court of India. So Supreme Court of India, I told all those cases, what are the checks, balances, which a judge must keep in mind while granting relief or not granting relief for section 151 of the CPC. That is a power of court to be used if there is no other specific rule in the same CPC. If there is rule on the CPC, invoke those rules or those rules. Then we can't invoke 151 CPC. The first test is whether this case falls under any of the orders or rules of CPC or not. If it falls means you have no power at all. No person you are subject to, no person you are subject to satisfaction. You have no power at all. If there is no covered rule or rule of procedure, then only you can act upon. Then you can act upon subject to the case law. They say exercise with caution, care, everything. Think 4 times before granting order. And you must draw your source from these case laws which I have told. I cannot say I feel proper, I have allowed it. Not like that. High Court, Supreme Court will not, listen to you. Sir, according to me, fit case, I have granted. The point is, fit case means to be tested on the anvil of law. Law must sit there. There must be source for you to say that grant it. Source for you to say don't grant it. So I've answered your question. So this power which is subjective is also subject to the apex court's decisions, high court decisions, and there's not a blanket permission. If I feel, grant it. If I don't feel, dismiss it. That's not the rule, because we are governed by rule of law. So my point is follow the principles of those cases which are discussed and told you in brief. And the first case I told you 6 principles. They touch all the aspects. I told rest covering different scenarios. I had posed 4 problems. I've touched there also. So I think I have made myself clear about Vivek's question regarding the element of subjectivity, and for your principal also. For example, I apply for admission for first year law. I am qualified. He cannot say don't. He cannot say that he will not admit me. If I fit the criteria, I have to be admitted. So here law also, we have got the parameter of case laws. So where there is no legislative guidance, we have to rely on the case laws. And precedent is also one of the sources of law. Custom, precedent, legislation, and they all are the sources, but custom also the source of law. I told the example of Beergal. Say since so many years they say justice is available freely to all, and now also we got free legal aid also. I am a poor person, I can't pay court fee. Law says you come to our forum, who will pay court fee? From government, will employ advocate. We have got the forum called as legal service of authority at all levels. Yes, some more questions?
One final question, sir.
Yes, sir.
So the question is, the students are saying we are clear that 151 cannot violate the provisions of CPC. In
Yeah.
the sense, express provision they can't go. But if let's say the other law is providing something, let's say section 74 of Contract Act says liquidated damages maximum amount can be given. Can the court use 151 to negate 74 and say that okay, in this instance damages over that can be given? Is the question.
Say Contract Act is again a substantive act. There's not an act, there's not an act of procedure. To invoke provisions of the Contract Act, to give effect to your contractual terms, but invoke CPC only. Which court to file and which court has got a jurisdiction, how to file the plaint, all those things are in the scope of the CR in the CPC. So here, in case of payment of liquidated damages, the contract says if defendant defaults, plaintiff can get from the defendant, but it so and so as the damages which is fixed beforehand. That is the quantum fixed by the parties beforehand. In case the defendant commits breach of contract, and there's no fault of the plaintiff must get by default what is called as the amount fixed as liquidated damages as a contract. The only point is performance or non-performance of the contract by the parties. If defendant defaults and plaintiff was not at fault, plaintiff shall get, court has no option. Court must allow your suit as paid for. And here the point is, 151 of CPC cannot be invoked by the court. Because recovery for amount of dues, what is the relief which you can get from the the CPC? File plaint, order 7 of the CPC. And we have to look to the point of jurisdiction, look to the point of pecuniary jurisdiction, so all those things. So here, when the contract provides the fixed amount as damages, the thing which court can see is default or following of terms of contract by the parties. If plaintiff succeeds that he was not at fault and the other party was at fault, and if all the things are fulfilled, court must decree the suit automatically. I have no option. I cannot invoke 151 CPC and dismiss suit. If I dismiss it, it will be a wrong order. High Court will settle the order. I told example of Delhi High Court granting interim license of copyright, which copyright board also had no power. Copyright board had the power, grant it or refuse it. They had no power to grant interim license. And this man applied to the copyright board for grant of interim license. They rejected it. That order was taken to the Delhi High Court. Delhi High Court told, yes, grant him license interim. Supreme Court told it's a wrong order. Statute says give one thing, You cannot invoke section 151 CPC to undo what statute states clearly. What law prohibits, I cannot make use of section 151 CPC. That is the principle of the case law which I quoted.
Thank you, sir. I
I
think
made one.
you have made it extremely clear to all the students. We thank a lot. Mansi, over to you.
Thank you for your wonderful session, sir. Now, I would like to request Prakruti, Miss Prakruti, to proceed with vote of thanks.
Yes. I'm not able to hear you properly. Yes.
Thank you, Mansi. Good morning, all. I take this opportunity and I deem it a great honor and privilege to propose the vote of thanks for this knowledgeable lecture. And first and foremost, I would like to thank our guest, Vishwanath V. Angadi, sir, for his for his enlightening words and experience in his field. And thank you, sir, for giving the minute details under the topic. And I thank our beloved principal, sir, Dr. J.M. Mallikarjunaya, sir, for his opportunity and support, without which this lecture was not possible. And I would like to thank our IQAC coordinator, Dr. Manoj Kumar V. Hiramat, sir, for giving his encouragement to us and making this event possible. And I would like to thank my friend Trishla for giving us all the reading material on this topic. And lastly, I thank all the faculty members and my friends for patient listening and their contribution and making this event a successful one. Thank you, everyone.
Thank you, sir. Thanks a lot. It's been a great privilege to listen to you, sir. Thank you, sir. I'll contact you. You're on mute. Sir, you're on mute.
I want you to score more than CPC. And if this question appears as a question, you must write in full, at least out of 10, 5 case laws. And quote the case name, citation, brief facts, brief principle. Because I just read your note. The note contains I just read it. You are given Meera Chavan, Harsh Bisoni, I discussed. I told you the facts of the case and backdrop of principle involved. So this case I have touched, and I also touched one more case also. My point is, quote the case law, but tell their brief factual matrix, because it will be more fine, because even the reader knows that you have got acumen, you have got legal acumen. And you said last is Ram Chand and Sons Sugar Mills versus Kanaya. I told you, in this case also, the apex court held that if the order which you are passing conflicts with rule of law, then order is bad in law. And you just quoted the important words, but I quoted you what you call the important fact of that case also. So with this, thank you. I think I have taken more time. And I wanted to speak to you about all the 10 case laws, because I had prepared it. Unless I deliver and tell you, my talk will be rather not complete. And if I have overshot your time, kindly bear with me. And if there are other speakers for the next session,